You're walking down the street. A police officer stops you. They don't arrest you. They don't read you your rights, but they start asking questions and then they pat you down. Is that legal? That's called a Terry stop, and most people completely misunderstand what that actually allows. Let's break it down clearly. A Terry stop comes from a 1968 U.S. Supreme Court case, Terry v. Ohio. The court ruled that police can briefly detain someone if they have reasonable suspicion that criminal activity is happening, has happened, or is about to happen. Not probable cause. Reasonable suspicion. That's a lower standard, but it still requires specific, articulable facts. Not a hunch, not "you look suspicious," not a vibe. The officer must be able to explain why they suspected criminal activity. Reasonable suspicion means there are observable facts that would make a reasonable officer suspect crime. Example, someone pacing back and forth outside a closed store late at night, repeatedly looking inside and conferring with another person. That was actually the situation in Terry v. Ohio. Simply standing on a corner, recording in public, refusing to answer questions, those alone do not automatically create reasonable suspicion. Here's the critical part. A Terry stop does not automatically allow a search. It allows a limited pat-down of outer clothing, but only if the officer also reasonably suspects the person is armed and dangerous. Two separate justifications. Reasonable suspicion of crime allows the stop. Reasonable suspicion the person is armed and dangerous allows the frisk. The frisk is for weapons. It is not for evidence. It's supposed to be quick and limited to checking for weapons that could harm the officer. If, during that pat-down, the officer immediately recognizes something illegal by touch, like a weapon or obvious contraband, that can sometimes escalate things, but it does not start as a full search. A Terry stop must be temporary and limited in scope. It can't turn into a prolonged detention without developing probable cause. If it becomes extended, coercive, or overly intrusive, courts may treat it as an arrest, which requires probable cause. Let's simplify it. Casual encounter, you're free to leave. Terry stop, you're detained briefly based on reasonable suspicion. Arrest requires probable cause. That's the ladder, and where an interaction sits on that ladder determines what's legal. The Fourth Amendment protects against unreasonable searches and seizures. A Terry stop is considered a seizure under the Constitution. The Supreme Court allowed it because officer safety and crime prevention were considered important, but only under specific limits. When those limits aren't followed, evidence can be suppressed, cases can fall apart. So, here's the bottom line. A Terry stop allows police to briefly detain someone based on reasonable suspicion and to pat them down only if they reasonably believe the person is armed and dangerous. It's not a free pass to search. It's not the same as an arrest, and it's not based on feelings. It's based on specific, articulable facts. If you want more breakdowns of legal standards that people throw around without explaining, subscribe, because understanding the standard changes everything.